The short video seminar series titled Planning for Your Life and Legacy will cover several important topics including wills, trusts, powers of attorney, and retirement planning. Our speaker is Bill Snyder, a partner at Huddleston Boland's Legacy Planning Group. As an overview, wills are legal documents that control what, to whom, and by whom a person's assets are distributed upon their death. If someone dies without a will, state law will dictate in place of that will. Trusts offer mechanisms for a grantor to separate assets from the control of those assets. Powers of attorney authorize someone to act on your behalf, whether in regards to financial matters or healthcare decisions. And retirement planning is financial planning designed to provide a comfortable income after retirement. It consists primarily of financial management and tax planning. Today's video is on powers of attorney.
A person should use a financial power of attorney in order to provide for a trusted person to step into his or her shoes and take care of the principal's business affairs if that person should ever become incompetent and unable to do so on his own. The alternative to a power of attorney is generally a lengthy, costly, and often unpleasant incompetency hearing, which most people would rather avoid. This is why it's advisable for everyone to have a power of attorney, just in case an incapacity should occur. An agent acting under a power of attorney can do a broad number of things, including deposit and withdrawal from bank accounts, invest assets, pay bills, sign and execute contracts, notes, deeds, and leases, access safe deposit boxes, file tax returns, sell real or personal property, vote shares of stock, receive funds and claims owed, make gifts, initiate or defend lawsuits, make funeral and burial arrangements, conduct business activities, employ non-medical personnel, and provide for recreation, travel, religious needs, and companionship of the principal. In fact, an agent can do almost anything that the principal could do himself, except execute a marriage contract, divorce, a will, perform a personal service contract, or vote. When an individual becomes incompetent and it is necessary to appoint an individual to manage business affairs, and that person does not have a valid financial power of attorney, it is necessary to go to court and have a conservator appointed for that person. That person will need to be examined by medical personnel who will testify that he is unable to handle his business affairs, and the conservator will then be appointed by the court in a public proceeding that will allow him to do substantially all of the things that an agent under a power of attorney could do. A durable financial power of attorney can come into effect in two different ways. It can be a standing power where upon execution of the document, the agent has the authority to act under the power of attorney. Or it can be what we call a springing power, where the agent does not have the authority to act unless medical personnel declare that the principal is incapacitated, and only under those circumstances does the agent acquire the ability to act on the principal's behalf. Medical power of attorney is a document which appoints an agent to make medical decisions for you when you are unable to. If you are in an accident and are unconscious and a medical provider needs to make medical decisions which require informed consent, that person is the person that they will turn to. If you don't have a medical power of attorney, then your medical care provider will appoint somebody for you that will make those decisions. That is generally going to be someone that is related to you based on relationship and age, and you're really at the mercy of the physician or the hospital as to who is available and who they will get. A living will is a document which gives specific instructions to medical providers as to how those providers are to treat someone who is in a persistent vegetative state. Persistent vegetative state is a state where a person is unconscious and has a terminal medical condition that is going to require life support via respirator, feeding tubes, or other similar types of medical apparatus. The living will provides instructions as to when that person is to be kept alive under those circumstances and when that person is to be allowed to pass on naturally. If you don't have a living will, then the decisions as to end-of-life care are going to be made by family members. And most people would rather not place that burden on the family members. And that's one of the reasons why a living will is very important. The living will reduces a person's wishes to black and white, which clear up any ambiguity and alleviate people from having to make very difficult decisions on behalf of a dying family member. The requirements for the execution of a valid medical power of attorney and living will are that the principal must be competent when he executes the document, and the directive must be written, signed, dated, acknowledged by 2 witnesses, and notarized. Other requirements include that the medical power of attorney is only enforceable if you are incapacitated. Incapacity is determined by a physician, psychologist, or other medical provider who has personally examined the principal. Treating healthcare providers, operators of a healthcare facility, and employees of a treating healthcare provider or healthcare facility who are not related to the principal may not serve as an agent under a medical power of attorney. The West Virginia Code contains forms for medical power of attorney and living will, including a form that contains both instruments.
Thank you for joining us for this informative video. Please don't hesitate to contact us at Huddleston Bolin for more information or to discuss your legal needs.